not heard in the matter of Chancellor Battersbee and Barts Health NHS Trust and others.
Mr Devereux, can I trouble you before we turn to Mr Miller? Firstly, to say this to everybody. This morning, we will simply hear the remaining submissions and then reserve our judgments, which we will aim to give orally, and we hope to do that at 11:30 on Monday morning. So that helps people manage their expectations of what will or will not happen today. The other matter to raise with you is that in the course of submissions, we obviously heard what you said yesterday, but we didn't follow through to ask what you say should happen should you be successful in your appeal on the ground that you've now formulated in your oral submissions. What do you say should happen?
The matter should be remitted to a High Court judge to undertake a comprehensive evaluation of best interests.
But
the difficulty...
That's clearly one of the options. Sorry, can the door be shut? That's clearly one of the options.
Yes.
Another option, which I don't think you would be suggesting and we wouldn't encourage, is to, at this stage, ask Mr Justice Hayden to give more reasons. I think that moment has passed.
Yes.
The other option is for this court to retake the decision on the basis that, as I would understand it, all the material is before this court.
Well, it isn't.
It isn't?
No. The judge had the benefit of the oral evidence of Dr. F.
Yes.
And the oral evidence, critically, of the mother, and indeed, you will recall, the father, who both of whom put in witness statements. And it was originally thought the father would not give evidence.
Yes.
But he did.
Yes.
Now, this court does not have a transcript of that evidence,
No.
any of it.
No.
And in circumstances where, if I were to succeed, in circumstances where there's a challenge as to the weight given to the wishes and feelings of the family, and particularly, and in circumstances where there isn't that evidence, it would be ambitious for this court to undertake the process that could be option 3.
Right. Option 3 being...
This court making...
Sorry, on that.
Option 2, going back to Mr Justice Hayden.
Procedural option.
Yes.
Yeah.
That's the difficulty. And I well understand that I can see that in other cases that is a possibility, but not in this case.
Right.
Yes, I'm not fully following what you're saying about that option. You mention evidence from Dr. F.
Yes.
What did Dr. F say that we can't perfectly well gather?
I don't have the transcript of what Dr. F said. No one has the transcript, so...
Yes, but it's possible to know, in a nutshell at least, what Dr. F.
Well, I'm not sure that, with respect, that knowing in a nutshell does justice to the case.
I appreciate that the case is an important one, and not only for those who are directly affected by it, but this question is not really about disputed facts. It's about proper procedure, proper decision-making.
Yes.
And it's not taking place against a context of controversial facts.
Well, it isn't.
And so when you say the mere fact that we haven't heard from Dr. F disables us from taking a view, I think I, for one, would want to know the sort of thing that Dr. F may have said.
Well, I certainly can provide that. I certainly can provide that, but of course that's only one part of what I say.
No, I'm taking it in pieces.
Oh, forgive me.
Similarly, I think I'd, at least for my own part, want to know what it is about the parents' evidence that is, you say, would not be adequately reflected in the material that we have already.
At the moment, my lord, what you don't have is a transcript, and I don't have it, and I wasn't at the trial. what you do have is a limited summary of the parents' evidence derived, it appears, from the statements that they provided and also from their oral evidence. But you also have that in the context of Mr Justice Hayden's observation at paragraph 45, or
Yes.
whichever one it is, about the ambushing of their objectivity. And that, in my submission, rather colours the definition and the import and the importance of the quality of the parents' evidence. And the further point is this: if there is, and this may be a good point, it may be a less good point, but it's a point nevertheless, if there is, in a case such as this, a challenge to the proprietary procedurally of a judge's reasoning, in my submission, this court should stretch its sinews to ensure that fairness is not only done, but seen to be done. And the process by which this court, if it were to go down that path, undertakes the assessment without the benefit of transcripts, without the benefit of seeing the particular actors in this case, is something that might be regarded as somewhat unfair.
Thank you.
Thank you. Yes, Mr. Miller.
I'll start, if I may, by saying a few words about the law, because it's what I have to say is relevant to both the oral and the skeleton arguments.
Yes.
that we're answering. And it's probably most efficient to look at it in one chunk at the beginning, because all the points feed into what comes later. The court has to act compatibly, this is the court taking the best interest decision, with Article 2 and Article 8, insofar as the rights of the patient and the family are engaged in this situation. That's straightforward, Section 6 of the HRA. Article 3 is often mentioned in this context and requires a public authority, of course, not to cause serious harm of the sort identified in Article 3, inhuman or degrading treatment. But withdrawal of treatment per se, which is the issue in these cases, will not do that. And so when one looks at the Strasbourg cases, Article 3 tends to play a much lesser role, if any, in the analysis. It's Articles 2 and 8 that are at the forefront. And it's important to remind oneself what the relevant wording of these articles is. Article 2, the right to life must be protected by law. That's the principle under Article 2. And we'll see in a second how that plays out under the Strasbourg authorities. In Article 8, the state must ensure respect for the private and family life of the person concerned, the patient or the child. The wording defines the content of the right, if you like, as to what the state, what the public authority, being the court, is supposed to guarantee and ensure. In this situation, where the issue of continuation of treatment has been brought before the court by clinicians, and there's disagreement with the parents who seek continuation of the treatment, these articles require that account is taken of three things: the opinions of the treating clinicians, one, to the extent possible, the wishes or presumed wishes of the child, and three, those of the family. In that analysis, the best interests of the child must be paramount. And approaching the matter in this way, a fair balance must be struck between the interests at stake. I want to look, if I may, at the Guard versus UK case, starting at page 932 in the authorities bundle.
Have you a tab number? If you haven't, don't worry.
No,
No, well, just give us a page number then.
Page 932.
Thank you.
I never know whether It's going to be done electronically.
No, my lord is electronic, so I will
Or-
defer to his technology.
A lot of muscle is
I've
going
got
to be
it
used,
separately.
as I do, with a very large
Yeah.
printed bundle.
My lady,
35.
tab 35.
35.
And what paragraph number?
Starting at paragraph 80.
Sorry,
This is-
80?
80.
80. This is at the top of page 932. This is the reasoning of the court in relation to the complaint in guard under Article 2, the first of those two provisions. And at 80, the Strasbourg court identifies the wider requirements in these cases, being the existence in the domestic law of the state and the practice of the state, an overall regulatory framework compatible with the requirements of Article 2, and that starts with the decision making by the clinicians. Whether account had been and of course, because these principles have to apply not just to judicial determinations, but also medical determinations. Whether account had been taken of the applicant's previously expressed wishes and those of the persons close to him, as well as the opinions of other medical personnel. That was one of the points I just listed. Thirdly, the possibility to approach the courts in the event of doubts about the best decision to take in the patient's interests. At 81, the court then looks back to the Glass case, which was the first in this sequence of cases, but also has Lambert in it, and observed that having regard to the detailed rules and standards laid down in the domestic law and practice of the state in this area, it cannot be maintained, this is the UK, that the relevant regulatory framework discloses any shortcomings which can lay the basis of an arguable claim of a breach of the domestic authority's obligation to protect the first applicant's right to life. The court is saying you can't rely on shortfalls in our regulatory framework, including the system that brings the case before the courts, to found an article to breach argument. Then importantly, in 83 and 84, the court notes no consensus exists amongst the Council of Europe member states in favour of permitting the withdrawal of artificial life and sustaining treatment, although the majority of states appear to allow it. While the detailed arrangements governing the withdrawal of treatment vary from one country to another, there is nevertheless consensus as to the paramount importance of the patient's wishes in the decision-making process, however those wishes are expressed. That's one of the other points that I mentioned a moment ago. And then importantly, as I say in paragraph 84, although the court considers that in this sphere concerning the end of life, as that in concerning the beginning of life, states must be afforded, accordingly, states must be afforded a margin of appreciation, not just so as to whether or not to permit the withdrawal of artificial life-sustaining treatment, which is obviously an issue in some states, in a way it isn't in other states, and the detailed arrangements governing such withdrawal, but also, and this is the important part, as regard the means of striking a balance between the protection of the patient's right to life and the protection of their right to respect for their private life and their personal autonomy. The court is saying, if you like, domestic law can fill in the gaps as to how you go about deciding these difficult issues in a particular case. And although this margin of appreciation is not unlimited, the court reserves the power to review whether or not the state has complied with its obligations under Article 2. So you could have a Strasbourg case where it looks at the reasoning of a domestic court, but provided it broadly complies with those principles, it's likely to be compliant, provided it's properly reasoned and strikes a fair balance. And then the reasoning under Article 8 is at paragraphs 106 to 108 in the Guard case, at page 935, a couple of pages on. 106, the court noted, again looking back at Glass, that doctors should bring conflicts between professionals and family before the court in these cases, And you'll recall that in Guard, the issue was a rather unusual one of a new form of treatment being used. So 107, the court says, facts of the present case are exceptional. The court doesn't have examples in its case law which addresses, one might say specifically, the approach being taken in resolving such conflicts. Nonetheless, it has on many occasions considered the manner in which the domestic authorities intervene when families are in conflict, often in situations relating to care and custody arrangements. And it brings into the Article 8 analysis in these cases those principles. And they are that the decisive issue is the striking of that fair balance between the competing interests, those of the child, the two parents, and the public order, or public interest. And that must be struck within the margin of appreciation afforded to states in such matters, taking into account the best interest of the child as the primary consideration. And that's repeated at paragraph 108. So as the court can see from these two passages, and I'm sorry I labelled them, but they are important because they basically draw together the entire thinking of Strasbourg on these articles. In these cases, the European Court reads Articles 2 and 8 together in these cases on this understanding that both will be engaged and essentially the same considerations will apply. And the upshot is, one could say put differently, if in the end there is a judicial decision after a fair hearing, with interests being properly balanced, and the best interest of the child being regarded as paramount, then there will not be a violation of either right, Article 2 or Article 8. That is the gap that's filled in domestic law and procedure and in practice. And we have handed up, because it didn't get into the supplementary, into the authorities bundle, but the court will know it, the case of an NHS Trust versus why. We don't need to look at it, but I'll just give you the reference to the paragraphs. Paragraphs 105 to 114 in the judgment of Lady Black in that MHA case. There is acknowledgement that those principles we've just looked at in Guard as to the decision-making and the approach to the decision-making are the applicable principles in our law.
Sorry, what
there's
paragraph?
a very clear... There's
what paragraph?
105 to 114, and Lady Black follows through the Guard approach in a court protection case or an incapacity case.
Yeah. Thank you.
And sees how the gap, I keep putting it that way, but how the gaps are filled in our domestic law and procedure compliantly with the Guard principle. Guard is in the line of Strasbourg authority, as I mentioned, containing the Lambert versus France case, which the parents have relied on. Now, that, of course, was a different sort of end-of-life case. The patient's wife was saying his wishes would have been for withdrawal of treatment, and other family members were disagreeing, so there was an intra-family disagreement. And if we go back to page 855 in the bundle, there was one paragraph in Lambert that my learned friend referred to yesterday and took you to, which was paragraph 178.
Yes.
This was under the Article 2 claim that was brought by the family members who were taking the position that Monsieur Lambert wouldn't have wanted withdrawal of treatment. But essentially the family members were disagreeing about what his wishes would have been in this situation. And it's not contentious. We looked at it yesterday. The last three lines are obviously not contentious. The patient should be involved in the decision-making process by means of any previously expressed wishes, which may have been confided orally to a family member or a close friend. But there is nothing in Lambert which prescribes how a domestic court should weigh the evidence and the views expressed by the family regarding what the patient presented in a particular case. All this is saying, obviously, is that the patient must be involved by that route, if you like, in the decision-making. The domestic law I described as the filling in of the gaps, is set out in paragraphs 22, 39 and 45 of Aintree, and we've seen those in the judgment. But I do want to just look at them, if we may, going to paragraph 198 in the page 198 in the bundle, because there is quite a lot in there. They're quite dense, and the wording is fairly carefully chosen by Baroness Hale, undoubtedly. And there are passages which often we all think we know and remember very well, but do bear just looking at again in detail when you're dealing with a particular case.
I'm interested in you describing this sort of decision as filling in the gaps.
Yes.
There are different ways of looking at it, aren't there? Isn't everything in there, in effect?
Isn't everything in?
Aintree and decisions of that kind. I appreciate you.
Oh, yes, absolutely.
You've set the scene by
Absolutely.
in relation to the Strasbourg jurisdiction, but what is described in Aintree, as it were, is a full route map, isn't it?
It is. But the problem is we face an argument in the skeleton argument that there have been breaches of Article 2 and Article 8 in this case.
No, I quite understand why you've taken us to guard and the other European authorities, but I was just asking for, as it were, taking up your position as...
absolutely. No, I'm in absolute agreement with that. I mean, as Lady Black says in Why, the gaps are compliantly filled in, and it's all there. That is the internal regulatory system.
So not so much the structure is laid down by the Strasbourg jurisdiction, but the English law has developed in any event in a way which is compatible, you submit, with that, but it's more sophisticated.
Yes.
It's not simply filling in gaps. The English law had developed its own approach separately, which you say is compliant.
Yes.
I
only use the phrase in filling in the gaps in the sense there is a margin of appreciation of what happens domestically, is that you put something in.
Well, I don't think we should be hung up on just one phrase you've used.
Yes.
Yeah.
So in paragraph 22 in Aintree at 198, there's the well-known principle that the issue is whether it's in the patient's best interest to give the treatment, and it's only if that is the case that continued treatment will be lawful. Then at 39 on page 204, which in many ways is the key paragraph, but as I say, very, very condensed, and one needs to unpack it perhaps a little bit, is the familiar principle that the court has to consider the welfare in the widest sense, including, importantly, what the treatment involves, what the outcome of it for the patient is likely to be, and putting itself in the child's position to the extent possible, ask what their attitude towards it would be likely to be. And it's very important, we would respectfully suggest, to note Baroness Hale's words, try to put themselves in the place of the individual patient and ask what his attitude to the treatment is or would be likely to be. So what the court is saying is that, by way of judicial recognition, this is something a judge must attempt to do as best they can, but sometimes it will not be possible to do this with certainty and precision. And it's not a standard of proof, not a balance of probabilities. You've got to look at what the likely wishes of the patient would be. Baroness Hale returns to that point of paragraph 45, which really has 2 points in it, it seems to us. The first one is in the first part of the paragraph. This exercise is not about formulating the wishes and feelings of a hypothetical reasonable patient in the child's position. It's about that child or that patient. But then what happens after that in this paragraph is that some guidance is given on the difficult issues that are going to arise about the wishes of the patient, in particular child, as in this case, that is not to say the wishes must prevail any more than those of a fully capable patient must prevail. We cannot always have what we want, nor will it always be possible to ascertain what an incapable patient's wishes are. Even if it is possible to determine what his views were in the past, they might well have changed in light of the stresses and strains of his current predicament. And respectfully, that wording could have been drafted with this case in mind and the findings of the court in this case in mind, and indeed the findings of the Guardian. So, apologies, I've taken 15-20 minutes and probably told you a lot of things, you know, or reminded you a lot of things. You know,
No, it did help.
but they do become important when we come to look at the skeleton and the oral argument.
Thank you.
So I turn to what I'll call the oral case that my learned friend presented yesterday. We say that the judgment of Mr Justice Hayden has to be read as a piece. The entirety of it has to be read to follow the reasoning and assess the reasoning and the quality of the reasoning. That's obvious. And you have to assess any attack on the reasoning in the light of the law that we've just been through. That's also obvious. As learned friend acknowledged yesterday, it has a structure, the judgment. He went through it a couple of times under a series of headings. With respect, we're not sure he did it justice in the way he took you through it. And again, very briefly, our analysis would be this. First of all, in the introductory paragraphs 1 to 5, he describes how the case came back to the family division, including in the last sentence, paragraph 2, an identification of the ultimate issue, the best interest issue, and the need for what he described as an unswerving focus on Archie. There's then a section at paragraphs 6 through to 23 where the medical evidence is discussed. And it's important to look at paragraph 7. This run of paragraphs is introduced by the observation that there is a unanimous professional consensus, which is bleak. But nonetheless, the relevant evidence has to be highlighted, the key features of it. And I would just mention, obviously it's been read and I can take it as read as a whole, paragraph 18,
Yes.
which refers to Dr. F confirming Dr. Playford's conclusion that the expert's conclusion that there is no prospect of any meaningful recovery, and then deals with the detail of the day-to-day experience of Archie and the treatments needed, and those are then set out in the balance of the paragraph over the page in detail to show, it seems to us, the challenges and the implications of that treatment.
Yes.
Forensically, as it were, by
Yes.
reference to the evidence given.
There's 16, 17 or so specific ways in which Archie is having to be treated. And so I thought that this was helpful to help me understand just how powerless Archie's condition is. It's not simply the case, and that would be bad enough, of a person on a ventilator. This is a person whose every bodily function to maintain the integrity of the functioning of the body is supported in some way by medical intervention.
Yes. This is the reader is
Not
being,
just breathing.
No, the reader has been told this is what is having to be addressed. This is how it's having to be addressed. Is being addressed, and it's very complex and multifaceted. Then at the end of paragraph 23...
Can I just ask you about the paragraphs referring to Dr. F in the light of my exchange with Mr. Tevericks earlier this morning. Are we to understand that, in effect, the evidence of Dr. F is summarised between the beginning of paragraph 18 and the end of paragraph 22?
Yes. And that includes the witness statement, which we have, which is in supplementary bundle page 290. The core of Dr. F's...
I'm just looking through it because it starts by referring to the fact that Dr. F is giving a description, and then we have the list that my Lord has referred to.
Yes.
And then we go on to further aspects of the medical predicament.
Yes.
And then the judge appears at the beginning of paragraph 22, as it were, to take up his commentary on the evidence that he's been hearing. But obviously, others will be able to comment on this from their close knowledge of the underlying evidence, oral and in statements.
Yes.
But the account given by Dr. F we can take to be in paragraphs 18 to 22 inclusive.
We can take it that it fits with the full account given by Dr. F as the treating consultant intensivist in a series of statements culminating in the 5th of July statement. So it's all, I'll be correct if I'm wrong, you can find pretty well all of it in there. But it does come from other places as well, because of course other doctors gave evidence, Dr. Q and Dr. E in particular. But Dr. F did attend on video link before the judge and spoke to her most recent witness statement. Then, importantly, moving on, paragraphs 23 and 24, it seems to us that there are three important sentences. The end of 23 and the beginning of 24 that are intended to frame not just what I call the ultimate issue, at the high level of abstraction, what the best interest issue is about generally in these cases, but the particular issue in this case. Eventually Archie's organs will fail and ultimately his heart will stop. How, when and in what circumstances is impossible to predict. What I have set out above is a bleak prospect, but in invidious circumstances it is one that his parents are driven to prefer. The alternative is that advanced by those caring for Archie and his guardian. So this observation is with respect to a succinct summary of, on the one hand, the parents' position for continuation of the treatment that's just been described in the judgment, contrasted with that of the clinicians and the guardian. So the judge is setting up the particular issue that needs to be decided in this case. We say in very clear and very certain terms. Then at the beginning of 25, there is a second straightforward and clear, familiar self-direction regarding best interests and the need to focus on Archie, followed at 25 to 30 by an account of Archie, the boy before the accident, showing his love for his family, especially his devotion to his mother, his love of life, his physicality and talents in that area, his love of sports. And then the passages that we've seen at 30 regarding his faith and 31 regarding the conversation with his brother and his mother. And I won't go through those, we're familiar with them and we've read them.
I think just as you were mentioning all that and you highlighted Archie's relationship with his mum, I think it rightly, if you pointed out, you should also refer to the very complimentary way that the judge referred to Archie's relationship with his dad as well.
And his father, yes. And the family as a whole, and the father who also gave that.
I only highlight it because you mentioned mum specifically, but not dad, and in that passage the judge deals with both.
And it's right to point that out, and the judge clearly made a point of identifying his love of both of his parents, and the evidence showing that. This section has an important paragraph, it seems to us, at 33, where the judge says, acknowledging the mother's position as described in the preceding paragraphs, I am required to confront the compelling medical reality that Archie no longer has the agency to fight. His bodily autonomy has been devolved to the clinical machinery, medication, and nursing care. And we would respectfully suggest that has to be held and read with the later reasoning about his position and in particular his loss of bodily autonomy, because the judge is there setting up what we come to see in the concluding paragraphs at 45 and 46. There are then the various self-directions as to the law at 34 to 41, which disclose no error or misdirection. They include the key paragraphs in Aintree, and at paragraph 39 include recognition that his Archie's Article 2 and 8 rights are engaged, and referring to the presumption of state protection for life under Article 2. Though of course, and I emphasise this, as we have emphasised in our analysis of the law, these simply require him to do what he is doing here in applying Aintree. But those are the demands of Article 2 and Article 8. So in truth, there is not much more to be said about that than is in paragraph 39, because he is working and directing himself working with and directing himself according to the principles in Aintree. And then we come to the reasoning on what is the ultimate issue, which we say is paragraphs 42 to 46. This is where the judge comes to the things the court has to balance under Article 2 and Article 8, according to Guard versus UK and Aintree. And they're returned to here, but obviously we say you have to read these paragraphs in light of everything that's gone before. They are implicitly drawing in everything that has been said about those topics, those interests and issues in the judgment before. And we would include paragraphs 42 to 44 because it seems clear to us that he was adopting these parts of the Guardian's reasoning as steps towards his conclusion, or part of his reasoning in his conclusion on best interests. She had the same conclusion. It's convenient to put them in the judgment in this way, and it's legitimate to reason in this way, given the clarity and the quality of these passages in the Guardian's report. There's no point in the judge trying to reinvent what the Guardian says in the judgment when it is so clear and straightforward. So what are those headings? Well, the wishes of the family to continue treatment, especially of the parents, have been identified in the earlier parts of the judgment. They are encapsulated in the references via the Guardian's report, paragraph at judgment, paragraph 42, and the references to wanting more time for Archie and the family's view about his religious beliefs in the passage at 43 in the judgment from the Guardian's report, and what the family get from the maintenance of life at the passage at paragraph 44 in the report. So that's the judge using that report as a tool to articulate his reasoning. As to the presumed wishes...
He's quoting from the report, but isn't Mr Devereux entitled to say, yes, at paragraph 42, he records the mother's position about religious belief and that Archie would wish more time, but we can't read what weight the judge gave to that. He's listing it as one of the factors, but we struggle, says Mr Devereux, to see how it's brought into a final analysis and where it sits in the balance between option 1 and option 2.
Yes, well, one wonders what would be said about that on the facts of this case. I mean, the obligation under guard is to take those views into account. And what we'll say when we come to the end of this is a pretty clear and strong conclusion by the judge in favour of not continuing treatment for the reasons he goes on to set out. So it's difficult to know exactly, when my Lord says wait, it's difficult to know exactly what a judge would be saying about that. You know, taking it into account, but in the light of the other considerations that point in the other direction, it's not a sufficient consideration to produce a different outcome.
Here, in the awful circumstances of this case, there was an important but narrow choice to be made. Leave things be as they are in the acceptance that everybody has that in a relatively short time, Archie's body will be able to tolerate this no more. He will die at a time that can't be predicted, but it will happen, it's thought, in the coming weeks. Or arrange for the removal of the systems that are supporting life now, with the inevitable consequence that he would die at that time, but in a way that has everyone knows that's what's happening, the family can attend, and all other arrangements were there to support. So there was a choice to be made there. The judge makes a choice, but Mr Devereux's submission isn't it incumbent on the judge to indicate why he's chosen the one over the other? As the family say, yes, we understand what's said about removal of treatment, but we, for the reasons we've given, say it's better just to let God, in their terms, take whatever action or intervene or not, as the case may be.
Yes, well, I mean, I'm not. This is ultimately a matter for this court, isn't it? How they assess how much or how little the judge said on that point, and I'm not going to say more than I've said already. Really, I mean, it seems to us that it's taken account of. The views are articulated in the judgment and taken account of. It's implicit that they do not produce a different result. But if it's going to be said, well, a judge in this situation could and should have said more than that about that, that's a matter of judgment, and it's really for this court to decide whether that was the case and what the consequences of that are. That's this court's conclusion. But it doesn't seem to us, and I'll come on to this in due course, that in terms of what happens now, whatever criticism might be made of the judge about that, it points to a different outcome, or points to remission of the case. It seems to us pretty clear what the judge was saying and what his analysis was, and it seems pretty clear to us what the weight of the evidence demands in this case. But that is obviously a matter for this court. I mean, I'm trying to analyse the judgment. If there were other passages where more was said about the weight, as Mill puts it, I would take it to them. But
yes.
It seems to us.
And it certainly, and I made this observation yesterday to Mr Devereux, it's very difficult to say that the judge didn't have each of the 6 points that he says favours option B in mind, because he mentions they're all there in the judgment. Yes. But Mr Devereux's submission, as I understand it, is we don't know what he made of them. We don't know why, despite having those points in mind, he chose the hospital trust's preferred route as being best for Archie.
Well, I disagree with the first proposition. I think we do know what he made of them. We may not know enough about what he made of them. I think that's really the point. That we could have known more.
I think your submission essentially is that if there is anything missing, it's probably no more than a paragraph. And based upon the judgment as a whole, that paragraph writes itself.
Yes, absolutely. It's an articulation, a greater articulation of what's in there, but it is a greater articulation. As far as the presumed wishes of Archie are concerned, which we've looked at the passages in Aintree, one takes it into account to the extent possible. That is dealt with in that important final 5 lines of the Guardian's report, the passage in the Guardian's report, at paragraph 43 of the judgment, where the Guardian says, I apologise, I don't want to steal Millen from Sunday here, but for the reasons highlighted above, I do not consider that he could have in any way foreseen the circumstances where they're being relied upon now. Given what I've been told about him, I would expect him to find the restrictions on his current situation difficult.
And you would reference that back to Aintree?
Exactly. It's exactly what that passage in Aintree at 39 and 45 is about. He's directed himself as to how that works, and he's adopting what the Guardian is saying about how that works. Really, there's not a great deal more to say about that. It's a very clear and concise and insightful observation, which the judge adopts. As far as the medical evidence and the opinions of the clinicians is concerned, which is the other thing that GARD requires the court to look at, judgment, paragraph 45 of the judgment, it seems to us, refers back to the lengthy discussion of the diagnosis and prognosis, where the judge refers to the reality of Archer's situation. And it's clear from the first sentence of paragraph 46, the judge is concerned with what he describes as the detail of the treatment needed to keep Archie alive, again dealt with in great detail earlier on in the judgment. And that part of 46 is preceded by the comment, important comment, that this is the most compelling of evidence. That is an emphasis on the weight he gives to the evidence, and he says it drives him to a certain conclusion. It doesn't seem to us that could be much clearer. It's expressed shortly, but it's very clear. Perhaps put differently, he's saying on that, having got to this point in the analysis and looking at the medical evidence, there is a clear and obvious case for ceasing treatment on the basis of the clinical evidence. And what I've heard about Archer's, what I consider to be the case about Archer's presumed wishes. The comment at paragraph 45 about the family's evaluation of the medical evidence is, we would suggest, both legitimate and important. It records their disagreement with the clinicians, which is one of the things that's important in Strasbourg terms, why the case comes before the court, and it's important to highlight that and respect it. And it gives the judge's view as to how it's come about and why, with the best will in the world, he regards it as misconceived, the parents' view as misconceived, but understands it. So at the end of the judgment, in those paragraphs, particularly at the end of 46, it seems to us he's giving his own thinking regarding the detail and the consequences of the treatment as being things Archie would not want to continue, but serving simply, as he puts it, to protract his death. So is this a balance sheet? Well, one can debate that. I accept it's not listed and presented as such, but all the required reasoning on the balancing of the views and interests in play, it seems to us, is in there. And with respect, it is obvious how each consideration plays into the ultimate issue, which is continuation or not of the treatment. It's not really necessary to say this is a factor for continuation, this is a factor against continuation. It's obvious when you read the whole judgment how they play into it. And so I suppose we say that read carefully and fully, it is, contrary to Malone Friend's submission, it is a careful, these are his words, a careful, clear, understandable and comprehensive evaluation of Archie's best interest in the widest sense. There may be cases where there is a case for a more formulaic conclusion, as I say, listing for and against factors or returning to them, listing them in that way. But we would respectfully say this is not one of them because of the way the issues are identified and the effect of the evidence. Some will be more closely balanced, some will be more complex. This is not such a case. And overall, our point is that applying the familiar principles in the cases we referred to at paragraphs 13 and 14 in our skeleton, and I won't take them, that's English versus Emery in this jurisdiction, and Hero Blanai versus Spain in Strasbourg under Article 6, which tell us what needs to be in a judgment for it to be full and proper judgment. Applying those principles, and as I say, recognising that the reasoning at 42 to 46 has to be read in the light of everything that's gone before, this judgment contains more than sufficient reasons in this case. It's compliant with the common law, it's compliant with Article 6, and it's clear why the judge decided the best interests were in favour of ending the treatment. So before I come to the skeleton case, which I do want to answer as well, that's really our case on the oral submissions that were made yesterday. Just 2 points to note, but I won't take any time over them. On the criticism of the judge for referring to no hope at all of recovery, paragraph 45. I think the court got the evidence on this yesterday because the learned friend was asked to direct the court to the evidence on this point.
Yes.
But for your reference, we've also dealt with it at paragraph 20 in our skeleton, at subparagraphs A and B, where we've dealt with the medical evidence on this issue of could there be a worthwhile recovery or a meaningful neurological recovery, and given the reference to that question and answer in Dr. Zed's evidence in the first hearing before Arbuthnot chain. That's the observations that Dr. Zed made about the available material for assessing chances of recovery for an adult in this situation and what that recovery might involve. On the point about the judge referring to a loss of dignity through the invasive treatment in circumstances where no pain is being experienced, we have dealt with this at paragraph 23C in our skeleton argument. Yes. By reference to the observations of MacDonald J. and Rakib, and we also summarise what we took Lord Justice Baker to be saying about this in Parfit, paragraphs 61 and 62. I confess those aren't easy paragraphs in either judgment. They take some looking at and analysis and understanding. So we think what we're saying is right. And on our basis of what Lord Justice Baker was saying in Parfit, we respectfully suggest that it was not inappropriate for Mr Justice Hayden to characterise Archer's position as undignified, or compromised in terms of dignity. Of course, whilst recognising the family may not consider this to be the case for very good reasons important to them, especially given their faith. But it was a characterisation, we say, that was open to him on the evidence.
And dignity has a meaning that we all understand and use in our day-to-day language.
Yes.
And something can be undignified, but essential.
Yes.
And there's
Exactly.
plenty of women that have had children would say that they spent an awful lot of time feeling undignified. That wouldn't be in a pejorative way.
And as I say, one refers back to the paragraph 18 of the judgment and the detail and the way in which the judge made a point of putting in very difficult detail about what the intrusive and invasive treatment involved. Seems to us that's the basis for that observation.
I suppose what I'm saying is you've spoken of the complexity of the analysis of McDonald J and Baker LJ, but of course it perhaps doesn't need to be that complicated.
Well,
it can just be, could be regarded as undignified having to have what's happening to him every day.
Exactly. I mean, we're just here responding to the points the other side take, but for our own part, we would say it is simply a judicial characterisation of the position on the evidence and unobjectionable as such. So, unless there's more, that's really what I wanted to say about the reasons argument that was raised.
Thank you. I don't think we have any questions.
So I turn to the skeleton case,
Yes.
which is a little more complicated.
Yes, I mean, obviously Mr. Devereux didn't advance any of the points in the skeleton orally, save as insofar as they were encapsulated in his wider submission. And we've read your submissions in response in your skeleton and that of Miss Watson. So there's no need to lay the ground out fully as if we are new readers, as it were, or as if Mr. Devereux is relying primarily on those matters. He hasn't abandoned them, but you take your own course. But there's no need to.
Absolutely, I will take it very shortly. The first point is, it seemed to us there was a theme, if I can put it that way, running through some of the grounds, 2, 4 and 5, that there may have been misdirections of law. Ground 2 is the suggestion there was a breach of Articles 2 and 8, which we take to mean a violation of Article 2 and 8, which resulted because Mr Justice Hayden hadn't directed himself properly as to what these articles required in a case such as the present, which was why I went through the earlier analysis of the law. And it seemed to us that, I'm not sure this was quite emphasised in the same way yesterday, but what was being said in the skeleton argument was that these articles required the judge in some way to treat the conversation with his brother and mother as such weighty evidence that he would have wanted the treatment to continue, that this should have led the judge to a determination that it should continue, and any contrary determination in light of that evidence would be a violation of the rights under Article 2 and Article 8. And that's why I took you to the demands of the authorities. There's nothing in the authorities to suggest that supports that proposition. Then there's, in ground 4, there is law cited to suggest Mr Justice Hayden was wrong in his characterisation of treatment as futile. But of course, it's not. He's not. He's recognising the purpose of the treatment, which is to continue life, continue the bodily function. But in other respects, it's futile. Because, again, that's an appropriate comment to make. And the conclusions at 46 in the judgment are self-evidently findings of fact anyway, they're not findings of law, about the treatment and its impact and consequences.
Well, looking at the skeleton insofar as it deals with these matters, this is the current skeleton. I don't think any law is cited except when we get to the section dealing with dignity. So it may be, well, I struggled to understand how there was an error of law involved in what is said at ground 4.
I think on 2, 4 and 5 it is important where there are references in the skeleton to Articles 2 and Article 8 to defend the judge's reasoning on the basis there is nothing in the case law in Strasbourg or here that would point into that as a necessary conclusion in this case, that treatment couldn't be continued. So ground 1 is straightforward, not dealing with arguments under Article 2 and Article 8. From my submissions, it's obvious. We accept, obviously, that the position statement of the parents before Mr Justice Hayden involved a lengthy assertion of those rights and in effect mirrored the arguments that are in the skeleton argument here, and did refer to Articles 2 and Article 8 being bolstered by the 2 UN Convention provisions. But again, our answer is simple, that those arguments are wrong as a matter of law. There isn't a basis for an argument for a violation under 2 or 8. And his rejection of those arguments was implicit, and as I said earlier, he didn't have to spell it out because he used entry, and entry gets you to the right answer on those issues. Ground 3 is really a ground about what's described as fact-finding errors. These were not errors. We've explained at paragraph 20 of our skeleton why they weren't errors of fact-finding. And I don't think I need to say a great deal more about this if you've read paragraph 20 of our skeleton. But in any event, there's no reason to think that if the judge had made what the parents suggest would have been the correct findings of fact about those issues, hope of recovery, and damage to the brain and the spine, in rather detailed observations, that it would have made any difference to the outcome of his reasoning or his judgment. Regarding, if I could just give you a reference regarding the specific point made about Dr. Playfor and the unresponsiveness he identified on clinical observation, which is referred to at judgment paragraph 6. It was one of the issues Dr. F dealt with in the witness statement of the 5th of July, paragraph 4 at page 290. So there was other evidence before the judge about that symptomatic unresponsiveness to testing by the clinician who was treating Archie. So although the judge referred to Dr. Playfor's evidence, he had ample evidence from other sources about Archie being unresponsive and showing no sign of being able to breathe independently of the ventilator. Ground 4, not errors of law, mischaracterised in the skeleton. Again, they're findings of fact, and as I say, they're dealt with in the skeleton argument of paragraph 23, but this is burdensome, futile, compromises his dignity, deprives him of his autonomy, and becomes wholly inimical to his welfare. So there's a big attack under ground 4 on the language used by the judge in those paragraphs. But it's misconceived because it's presented as some sort of error of law, whereas it clearly isn't. It's just the judge characterising his conclusion by reference to the evidence. And it was open to him to do that on the evidence. And then ground 5, we pretty well dealt with, strong presumption in favour of prolonging life. There's an attack on the conclusion that the treatment serves only to protract his death whilst being unable to prolong life. But it seems so this is a reference back to the finding at paragraph 23 in the judgment, which we looked at.
Is that where he uses the same phrase?
Yes, and says the Archie's organs will fail and ultimately his heart will stop.
Yes,
So it's
the phrase is in fact 24, isn't it?
23 and 24. It's a conclusion that's supported by ample evidence. It's expressed shortly, but it is a clear conclusion. And indeed, if one looks at the parent's position statement for the hearing, page 138 in the supplementary bundle at paragraph 3, the parent's position at the hearing was that his life expectancy was very limited and he could suffer a cardiac arrest at any time. So the judge was entitled to think, to an extent, it's not pretentious evidence. Again, that is nowhere near a breach of Article 2 or Article 8 because it's simply a conclusion on the facts in this case. So, unless there's anything more you want me to say, I'll just address the point you put to my learned friend. It doesn't appear to us that there's any viable argument here, if indeed one has been raised, that the conclusion was, overall conclusion of Hayden J. was wrong in the sense of being the product of a self-misdirection. That's not an argument that's available. Or one which no reasonable judge could reach on this evidence. It's well within the range of reasonable conclusions for a judge on this evidence. So if you're against us on the issue in the oral argument, there are aspects of the reasoning that represent a failure of reasoning in some way. In our respectful submission, it doesn't point towards a second remission to the family division. It may point to the judgment of this court recognising a limited failure in that respect and commenting on it for obvious and important reasons, because the court is seized of the issue of whether there was a failure in various respects in relation to the reasoning. But it can't change the outcome of this case. One would say with the heavy heart that everybody is expressing that view, and that should be the court's position. It simply is not a case for remission.
What do you say to Mr. Deverick's observation to us this morning that we're simply not in a position, if we allow the appeal on this ground, to make the decision again ourselves, because there isn't a transcript of key parts of the evidence, and secondly, even if there was, we haven't had the experience of seeing particularly the two parents give their evidence.
Well, that's a valid point, and it's a familiar point in this situation, looking at an appellate court and remission back. But on the other hand, the appellate court has to ask what the consequences of that material not being before this court are, and balance any limitations on this court's appreciation of the case and the facts in the case and the evidence that may flow from that against wider considerations. And in particular, the court will have to say, well, even on, let's take the best case, my learned friend can advance on that point, that having that evidence would suggest X or Y or Z. Would it make any difference to the outcome in this case, such as it would justify a remission? And it doesn't seem to us that it would. And in part, that's because of Lord's point that there were witness statements from the family, up-to-date witness statements from the family. Yes. And there was a witness statement from a lengthy witness statement from Dr. F for the hearing. So to take an example, I mean, obviously Dr. F appeared, I wasn't at the hearing, but I've read a note of it. There was a short period where Dr. F appeared on screen and was asked some questions. But in the greater scheme of things, that it's not easy to see how that would make a difference to the outcome. I mean, unless my learned friend was able to point to some critical case-changing point, a piece of evidence that came out there that needed to be looked at and weighed by a first instance. And I don't think my learned friend is saying that.
Thank you. Thank you, Mr. Miller. Yes, Miss Watson.
My lords, my lady, I hope that I can take matters relatively briefly, and I will endeavour not to repeat the submissions that you have already heard from Mr. Miller. I will focus my submissions principally on the oral submissions made on behalf of the parents yesterday and refined in the case that was put forward. It was apparent from the submissions that were put forward yesterday that the central ground now advanced is whether there was a proper best interests analysis carried out by the judge, not by the guardian. We submit that the judge, in common with the guardian, correctly directed himself as to the law, that he undertook a careful and sensitive analysis of the factors to be considered as part of that best interests analysis, both medical and non-medical, and he reached a conclusion that was open to him on the compelling evidence that was before him. In the submissions made by my learned friend Mr. Deverick yesterday, there was some considerable focus on the Guardian's report, of which they are critical and which they submit was accepted by the judge without performing his own analysis. It seemed to us that there was some attempt to use the Guardian's report as a vehicle through which to challenge the judgment. And so I would wish to address that briefly in my submissions today. It is our submission, firstly, that with respect, the focus on the Guardian's report was inappropriate. It is the judge's best interests analysis that this court is concerned with. Secondly, when one properly considers the judgment as a whole, the submission that the judge relied upon the Guardian's report without undertaking his own analysis is untenable. Thirdly, the criticisms that have been made of the Guardian's report, when it's properly considered in its entirety, rather than by reference to isolated paragraphs or single words, is wholly unjustified. And therefore it is perfectly justifiable and was appropriate for the judge to consider the Guardian's analysis as part of his review of the wide canvas of available evidence. Taking, if I may, the criticisms of the Guardian's report, which it appears to have been suggested has tainted in some way the judgment, it is, in our submission, quite wrong to suggest that the Guardian discounted, to use my learned friend's words, totally at zero, Archie's wishes and beliefs. The narrow focus on two paragraphs in that report, paragraphs 65 and 71, was, as I've already submitted, not appropriate. One must consider the Guardian's report as a whole, and when one does consider the Guardian's report as a whole, it is our submission that it is quite clear that the Guardian at no stage lost sight of Archie, of Archie's wishes, of Archie's values, and his beliefs insofar as they could be ascertained. The Guardian gave specific consideration to Archie's previously expressed wish not to have life support switched off because he wouldn't want to leave his mum, and she gave specific consideration to what his mother said about that he would try to get out of bed. That is very clearly set out in her report. My Lord Justice Peter Jackson put forward the position that this case, in fact, is not really about that single conversation or what was said by Archie on one occasion, but about Archie, his relationship with and his place within his loving family. The Guardian respectfully agrees with that position, and we submit that it is evident from her report that she fully appreciated that, and that is reflected in her assessment of the evidence and her ultimate professional judgment as to where Archie's best interests lie. In my submission, this is seen most clearly in paragraphs 66 and 67 of the Guardian's report.
Right. Do you know the electronic number?
431.
Say again?
431. my lord.
431. Thank you very much. Yes.
My Lord, the Guardian sets out there that she states in terms, I was unable to stop myself smiling when I heard about some of the things that Archie did as a child. He had been described as a character by his mother, and I fully accept that. Archie was clearly a young man with energy and a level of fitness required to take part in sports that he chose. The photographs I've seen of him provide proof of this. I wonder, therefore, what his wish would be if he knew the confines of his current situation, the restriction of laying in his bed with no ability to communicate, the constant procedures required to keep his body functioning that gives him no peace or respite. Even his mother's love close by, as comforting as that would be, he could only sense her presence there, but sadly he cannot. She went on to consider the care that Archie was receiving from the nursing team in paragraph 67. And she notes that Archie's mother has been with him at all times, together with his father and his other close family members. She records in her report they provide emotional support to him, and states, if Archie could ever have envisaged a situation such as this, I expect he would have known that his family would be close by him and supporting him no matter what. But given the severity of Archie's brain damage, he is sadly unable to know that they are there. In my submission, those are important paragraphs when one is considering the Guardian's overall analysis and the way in which she weighs Archie's previously expressed wishes in the context of a conversation with his brother at the tender age of 11. And in the judgment, in my submission, the judge makes clear himself that the rehearing was proceeding on the premise that Archie is alive and that the court should consider where his best interests now lie. And he specifically noted that the investigation requires unswerving focus on Archie. And in our submission, the hearing did have an unswerving focus on Archie. The medical evidence was unchallenged. It was effectively taken as read. And although the court did hear some evidence from Dr. F, the focus of the evidence was on Archie and his wider best interests. And the court heard principally from his mother, his father, and from the Guardian.
How long did Dr. F give evidence for?
My Lord, I think it was probably no more than half an hour, but I will be able to give the court specific times if that would be of assistance.
It's 48 minutes, we're told.
And the hearing was on one day, the 11th of
It was, my Lord.
July. And your point partly is that it would often be the case in these tragic cases for quite a bit of the hearing to be taken up with medical evidence. But because this was a second hearing and the medical evidence had been heard, there was a greater proportion of that time taken up with hearing from the family and focusing on Archie.
Absolutely.
That's your point. Archie as a person rather than Archie as a person who's being assessed medically than would normally be the case.
Precisely, my Lord. The focus being on Archie and bringing him to life in the court, effectively, was what the judge endeavoured to do. And the focus was very much upon Archie as a person, his personality, who he was before this tragic accident. And to assist the judge in trying, as he must, by reference to paragraph 39 of Aintree, to ascertain what his wishes might be, what his attitude to treatment might be. Dr. F was called only because an issue arose during the course of the hearing, arising from the letter that my Lord the President took the family to, the open letter, which put forward an alternative proposition for future treatment. And Dr. F was essentially asked to deal with the impact upon Archie of continuing ventilation and feeding, but discontinuing all other treatment.
And he dealt with that in some detail in his witness statement.
And indeed, my lady, that can be found essentially in the witness statement of the same date, the 11th of July, because effectively Dr. F confirmed that evidence orally. Insofar as there has been any criticism of the Guardian, when she gave her evidence, confirmed her report, and indeed read sections from that report, principally reading into the evidence paragraphs 71 to 74. And it is our submission that despite the limited time available to her, that the Guardian's report discloses that she undertook a comprehensive investigation and took into account the medical evidence as she must, but also had a very clear focus on Archie during the course of that investigation. I don't want to take up a lot of court time by going through that report, but in summary, paragraphs 10 to 20 of that report describe the Guardian's visit to see Archie, where she considers the care and treatment that he is currently receiving. She looked at the environment in which he was receiving that care. And at paragraphs 21 to 35, She describes her detailed discussion with Archie's mother, in which she sought to learn more about Archie as a person, his personality, his values and his beliefs. And it is clear from those paragraphs that she was endeavouring to ascertain what his attitude to treatment might be. Indeed, she asked that question of his mother, and that is set out in the report. The mother's views are reflected at paragraphs 26, 27 and 33 of her report, and Archie's father's views are reflected at paragraphs 38 to 44. The Guardian also sets out her specific investigation into Archie's religious beliefs and those of his family at paragraphs 28, 29 and 31. And all of that feeds into the section entitled Professional Judgment, which begins at page 429, paragraph 57, in which the Guardian quite clearly carries out an assessment of Archie's best interests in the widest sense. And although there was a focus on paragraph 65 during Muller and Friends submissions yesterday, and the Guardian was criticised for discounting in the sense of ignoring Archie's expressed wishes, in my submission that criticism was misplaced, and that is evident from a review of the report overall. And as I submitted, when it's considered in the context of the paragraphs that have gone before, and indeed those which follow, one sees a sensitive and careful consideration by the Guardian of Archie's wishes and those of his family. In addition, when discharging her functions, as my Lord the President noted yesterday, the Guardian is required to have regard to the welfare checklist in section 1.3 of the Children Act 1989, which mandates the consideration of the ascertainable wishes and feelings of the child concerned, considered in the light of his age and understanding. And the Guardian has made specific reference to the welfare checklist and the task that she has to undertake in paragraph 62 of her report at page 430. Yeah. And she goes further and notes that she must also have regard to paragraph 39 of Aintree and keeps that very much in mind. Indeed, at the hearing below, that Archie's wishes should be considered in the context of his age and understanding was a submission that was made by the Guardian in the position statement. I needn't take the court to it, but the reference is a supplementary bundle, tab 13, page 150, paragraph 25. But there, reference was made to paragraph 116, Roman 5 of Rakib. Again, I needn't trouble the court by going specifically to that passage.
But there's no, in the judgment, there's no indication that the judge took any particular account of Archie's age when he was approaching wishes and feelings. It reads as if he gave it the same weight that he would give to an adult.
Well, my Lord, yes.
He doesn't in some way put a filter on what Archie's wishes and feelings are. And so, to that extent, I don't think you need to make those. It's not a point before us.
I'll move on. I pause only for a moment, and I suspect I needn't trouble the court very long with this, because I think the court has the point in respect of the focus on paragraph 72 and the use of the word indefinitely by the Guardian. It was noted by the Guardian, I have to consider whether his life being sustained indefinitely in light of the medical evidence would be dignified for Archie and in his best interests. As my Lady Justice King observed, that word should be given its ordinary meaning, and it is plain from the evidence before the judge that Archie's life expectancy was not known. And I anticipate that I needn't trouble the court any further with submissions on that point, but I simply make that point for the sake of completeness. We submit, therefore, that it was entirely appropriate for the judge to have brought the Guardian's assessment into his overall evaluation of Archie's best interests. Indeed, we submit that he would have been rightly criticised had he not done so. And we further submit that the judge's consideration of the Guardian's report forms part of his workings, if one uses the mathematical analogy.
I don't think Mr Devereux was criticising the judge for doing it. Mr Devereux's submission went further to suggest, my word, that the judge had abdicated his role by simply quoting and endorsing the Guardian's. as the other way around.
Well, my Lord, in my respectful submission, where, as here, the judge has the benefit of a well-reasoned, careful and sensitive analysis from the Guardian, fulfilling her proper role, it is entirely appropriate for the judge to adopt that reasoning in his judgment, rather than repeating, as it were, an analysis that has already been carefully carried out and crafted in a report. You've been taken through the judgment a number of times now, and I don't propose to do that again. But we submit that the workings, as it were, are not confined to paragraphs 45 and 46. That the weighing of benefits and burdens can be seen in paragraphs 23 to 27 and in paragraphs 32 to 34. As my learned friend Mr Miller submits, those paragraphs are to be held and read with those concluding paragraphs. And it is to be noted that there is within the judgment specific recognition by the judge of the value of Archie's life. He notes that it's more than a raft of medical complexity at paragraph 25. And he also takes into account as a benefit being surrounded by and supported by his loving family, and that is at paragraph 27. It cannot be said in our respectful submission that the judge has gone through, as he has in detail, all of the factors that must be taken into account in the best interests analysis without conducting a balancing exercise, without that balancing exercise being performed. When the judgment is read as a whole, that submission is, with respect, not sustainable. Overall, it is our submission that it is clear from paragraph 46 that the judge has considered, as he must in accordance with Aintree, the effect of the treatment on Archie, that treatment being intrusive, burdensome and intensive, and that his conclusion was that that weighed most heavily in the balance. That is, we submit, evident from the way in which he sets out his conclusions at paragraph 46. And I do not wish to repeat the submissions that you've heard from Mr Miller, but we say that not only medical best interests were brought into that analysis, but the nature of the medical treatment, what it involves, the prospects of success, the outcome of that treatment, whether there are any benefits to Archie, were all factors that were evident from those concluding paragraphs, but when one looks at the way in which the judge has moved through those factors in the earlier parts of the judgment. I deal, if I may, finally, and I hope briefly, with ground 4 and what was point 5, subparagraph 4 in the speaking note that Mr Devereux provided to the court yesterday. And repeat the submission that is set out in our skeleton, that the judge was entitled to find that the treatment being provided to Archie was burdensome, notwithstanding the consensus of evidence that Archie is highly unlikely to be able to experience pain and that he has no awareness. I set out the Guardian's position at paragraph 37 of the skeleton. That's in the supplementary bundle at page 97, where reference is made to the case of Parfitt and Guy's in St Thomas's Children's Hospital and Knight. That was the case in which Milady recalled Lord Justice Baker made reference to the burdens of treatment for those children who have no awareness. And in particular, it may be helpful, it was said that the court would be taken to that passage, and I don't believe the court has been. So it may be helpful just to take the court to that in the authorities bundle, tab 16. Forgive me, I've lost the page number. It's paragraph 60.
We've got an electronic.
389.
It begins at 360 and then
360. Right.
Page 390.
Thank you.
I think. think the court has 389.
Yes.
It was said by Lord Justice Baker in that case, the proposition that no physical harm can be caused to a person with no conscious awareness seems to me to be plainly wrong. As I observed during the hearing, the law clearly recognises that physical harm can be caused to an unconscious person. In the criminal law, for example, an unconscious person can suffer actual or grievous bodily harm, and it would be no defence to a charge under the Offences Against the Person Act of 1861 that the victim was unconscious. The judge was, in my view, entirely justified in citing examples from the law of tort in which it has been recognised that physical harm can be caused to an insensate person. As Mr Malonis observed, if the proposition advanced on behalf of the appellant was correct, there would be no limit on a doctor's ability to perform any surgery upon any insensate patient. For my part, I fully endorse the judge's reasoning for rejecting the appellant's proposition at paragraph 76 of his judgment. And at paragraph 61, he went on to say the judge's approach is entirely consistent with the observations of my lady in Re A.
Would you like us to read 61?
The very beginning of that, if my lord, the court can read the first part of that, and then the final sentence through to the end of paragraph 62.
Okay. Thank you.
And so that essentially, in our submission, addresses the point made in relation to the burdens of treatment and the fact that burdensome was a term used by the judge in the judgment. We respectfully agree with the court that the judge made a finding of fact based upon the evidence that there was, in Archie's case, very sadly no prospect of recovery, and submit that findings that the treatment was intrusive, that it was burdensome, and that it is futile fall into that same category. In addition to the finding of fact that treatment serves only to protract death whilst being unable to prolong life. And therefore, overall, we consider that the appellants have not established that the judge's overall conclusions are wrong, having properly directed himself on the law, and has not reached conclusions that were not open to him, that no reasonable judge could reach. And to address my lord's question about what we say the court ought to do in the event that permission is granted and the appeal is allowed, we respectfully agree with the submissions made by my learned friend Mr Miller, that it would be appropriate for this court to retake the decision to adopt option 3, as Mr Devereux referred to it. The summary of Dr F's evidence in the judgment is as complete as it needs to be. You have the benefit of Dr F's statement, which effectively...
But as I understand it, Dr F's evidence, both written and oral, went to a proposal that's not pursued in any event. Precisely.
And so far as the parents' evidence is concerned, again, it is respectfully submitted that the judgment does faithfully summarise that evidence in a way that would not deprive this court of important evidence that it would need in order to retake this decision. And indeed, much of the evidence that was given orally is as set out in the witness statements, including those most up-to-date witness statements of the 10th of July, served just before the final hearing. And so this court would not be deprived of material evidence needed to retake that decision, in my respect to submission. And unless there are any other matters that I can assist.
Thank you very much, Ms Watson. Yes, Mr Devereux.
On the last point of Parfit, I don't want to be regarded as being too technical, but I simply make the submission that, of course, that was an application for permission to appeal, where Lord Justice Baker refused permission on all grounds. Characteristically, he gave very full and comprehensive reasons for so doing. There is, in this case, as the President has said, a choice to be made. And I want to be clear about that choice. The parent's position does continue to be that set out in the letter of the 10th of July.
Including the agreement to the withdrawal of the various treatments
That's my understanding.
that Dr. F.
And it's interesting to note that within the judgment there is not a reference to that letter. It simply is not...
was it put in positive terms?
it was put in positive terms in cross-examination of Dr. F.
No, I'm sorry.
I'm sorry.
I wasn't clear. Do beg your pardon, Mr. Devereux. Was the position statement and the parents' put case before the judge that the treatment should continue but altered in precisely the way set out in the letter?
Let me check with Mr. Quinterval. It was opened on that basis, and in fact, Dr. F gave the evidence and was cross-examined in relation to those particular proposals within that letter.
And so your present instructions, Mr. Devereux, is that notwithstanding Dr. F's evidence about the impact upon Archie of withdrawing, in particular the drug, that they would still advocate that as an appropriate course.
I wonder if I may assist, as I may very well be, on the front row at least, the only advocate who appeared in the court below. It was certainly the case that there was some discussion about whether an alternative proposal should be put before the court. And ultimately, it was confirmed to the judge that there were only two options that were being proposed: continuation of treatment or withdrawal of life-sustaining treatment. So he wasn't asked to consider an alternative, whether as set out in that letter or as proposed potentially by Dr. F in her evidence.
So consideration of treatment as set out by the judge in the judgment, as opposed to the moderated treatment.
Yes.
That was contained in the letter and dealt with by Dr. F in his statement.
Yes. Ultimately, no party put forward positively an alternative, or what I perhaps described in the lower court as any middle ground.
I'm not being critical, because certainly on the reading of the Dr. F's statement, it wouldn't be at all surprising if the parents felt that was no longer what they wanted for Archie.
Ultimately, my lady, although it had been raised in that letter, it wasn't put forward to the judge as a concrete proposal that he was being asked to consider.
And if it had been, you'd expect it to be in the judgment, particularly as the judge listed the 16 or 17 elements of treatment that were currently in place. If any, I haven't cross-referred, but if any of those were not going to be carried on, he would have said so.
Indeed. And his clear indication was that he thought that it was appropriate that no party was pursuing some sort of middle ground.
Certainly, from what I am instructed, Dr. F was cross-examined on the basis of the 10th of July option. Be that as it may, there plainly are different options available, and that is the heart of the dispute between the parents and the Health Trust. Yesterday, I sought to set out, perhaps a little quickly, at least 7 benefits in favour of the continuation of treatment. And I know that your lordship commented on 6 earlier.
No,
and
I did.
wanted-
There's my memory. I've got numbered 1.
Can I just go just to check?
We've
Yes.
got 7.
We've got 7.
Everyone's got
Yes,
7.
yes, and I went through the list as you repeated it yesterday. So
Thank you very much. I want to just deal with 2 further points, if I may. The first is a consideration of aspects of the Guardian's report, following on from what my learned friend said in her submissions. And second, I want to be as clear as I possibly can, because perhaps I majored on robustness rather than clarity earlier. I want to be as clear as I can why we say that this court is not fairly in a position to make the decision as to best interests. But turning then first, if I may, to the Guardian's report. In a sense, the construction of the Guardian's report, or of a Guardian's report, might benefit from at least a distant consideration of the structure that is suggested in the case of B, adequacy of reasons. There must at least be some structure within a Guardian's report. There must be an evaluation, and there must, in my submission, be ultimately an explanation as to...
sorry, but help me. Which submission are you making a response to in drawing our attention to that?
I'm seeking to make an overall response to my learned friend's assessment of her submission that the Guardian took into account and fairly attributed weight to relevant considerations.
Right.
And if one turns then to the Guardian's report, I just want to emphasise some limited aspects. The evaluation and the explanation comes within paragraphs 57 to 74. And if one starts at 57, one sees at 59 the record of the medical consensus, 61 the assertion that she starts in the clear and unquestionable knowledge that Archie is special and important to many people who know him as well as to many more whom he's never met. She then gives herself a self-direction as to best interests and Aintree.
Well,
She-
you missed out 60, where she, probably because it's at the bottom
I
of the
didn't
page.
mean to miss it out.
No,
It wasn't
the
a sleight of hand related.
just listen, but just because it's at the bottom of the page, but it immediately includes the family's views and
Yes.
her understanding of the
Yes.
challenges faced by the family in accepting what the medical
Yes.
evidence is. So
Yes. Then at 63, acknowledgement of the difficulty of this particular situation, as opposed to what might be described as a traditional dispute as between parents or parents and a state body. Then at paragraph 64, and this is the essence of her record of the parents' views, I submit. I'm not seeking to overlook paragraph 60, but 64 is the essence, or at the very least 60 and 64. Then the critical, I submit, passage at paragraph 65. So she reflects upon the insight that the parents provide in relation to Archie's wishes. But then there does seem to be a counterbalance or a context, or I'm not going to use the word discount because I don't think that's helpful, but a diminishment perhaps where she says it's difficult to imagine that when that innocent conversation took place between these two close brothers, that Archie at his tender age could ever have thought.
Mr. Devereux, I'm still struggling to understand what the submission goes to. We've got your grounds of appeal. You didn't make any oral submissions about those. You developed a new basis of appeal,
Yes.
which we obviously gave you full scope to develop, and you were obviously right to do so. But I don't think that included a criticism that there was some major fault in the Guardian's report, and that the judge was therefore in error in relying on that
I'm sorry if I've
badly
not.
flawed Guardian's report.
I'm sorry if I've not been clear or helpful. What my learned friend appeared to me to be saying was that a part of the workings, I think that was her word, of the judge's reasoning as to best interest was an integration
Yes.
of the Guardian's report. And what I'm seeking to do, perhaps not particularly persuasively from what I can
Well, no,
see,
I mean,
is to...
but I just, it helps me understand a submission to know what it is, what point in the appeal
It goes
it's
to
addressed to.
it goes to the speaking note at paragraph 5.1, because my learned friend says, well, the judge, as part of the workings of his attribution of weight in relation to Archie's wishes, he brought in, he integrated
Yes.
the Guardian's position, and I'm indicating, or seeking to submit that she herself doesn't give appropriate weight to those wishes and feelings. The other point that I want to make before moving on from the Guardian's report, is in relation to paragraph 73, which is at the end of the report. And again, I'm acutely conscious of falling into the trap of seizing upon a word here or seizing upon a sentence there. But I do note that in her assessment, she indicates that she's outlined the benefits that Archie's family derive from his life being supported. And that might, on one interpretation, at least indicate a not intense focus on Archie himself. I make that simple point. I want then to, if I may, move then to the bigger point, which is...
Are we leaving the Guardian's report?
Yes.
It just strikes me that at some point during this hearing we should reflect on the fact that the Guardian was appointed on the 4th of July.
Yes.
This is a report running to 18 or 19 pages and delivered on the 8th of July,
Yes.
4 days later, where the Guardian has conducted some quite extensive inquiries and has reported what she's found, and has, as her responsibility must be, applied her professional judgment
Yes.
what it is that she's hearing. And so, for example, when she's referring to the wishes expressed by Archie, it is her professional responsibility to consider those in the light of his age and understanding. And at the moment, I appreciate that the conclusion is one that was controversial, but I'm absolutely struggling to see how any criticism at all can be addressed to the way in which the Guardian has approached her task. She may be right, she may be wrong, and the judge may or may not have been right to rely on what she said.
Well, first of all, my lord, I pay tribute to the Guardian for the remarkable industry that plainly she performed under intense pressure of time and the situation. And second, I totally acknowledge your lordship's position, and I've made my submissions on the Guardian's report, and I think that my time is better spent dealing with the second major point that I want to develop, albeit briefly. And that is why we say this court is not properly in the position to make a decision about the critical aspect of best interests. And we rely on a number of points, if we may. The first is that this court doesn't have all of the written evidence before it. There is a great deal of written evidence, and this court doesn't have it.
Directed to what?
Well, directed to...
I mean, obviously this court doesn't have the huge, vast trawl of medical evidence, but the judge made a finding of fact that there was no hope of recovery.
Yes.
And that was accepted, and I
Yes.
think is continued to be accepted. So
Yes.
this court wouldn't require any of the medical evidence.
No, but what this court doesn't have is for example, 3 statements from Ella Carter, who's
Are
Tom...
you sure?
Oh, perhaps you
Well,
do.
I've certainly read them, but not for this.
Perhaps you do.
We do have them.
Oh, I'm so sorry.
As part of the 556-page supplementary
Yeah.
bundle.
I think we've
They
got...
appear at 373.
Characteristically, the court is ahead of me. I've read
Well,
them a number
I
of
think we
times.
have the advantage, Mr Devereux, because as I understand it, you picked up papers at very short notice, and one can only admire your...
I did read them, my lady, too, but I just
well,
forgot they're in the...
just feeling them.
Yes. No, I did read them.
No, we understood that. We are just
Yes,
conscious
and-
that you may not have known
And
precisely where in the
plainly,
bundle
you
were.
were in the first appeal. So
Yes.
You like my lady and I, would have read them for that.
Yes.
But we see Ms Carter's statements at tabs 28, 29 and 30.
I note it now at pages 373 onwards.
Yeah.
What you certainly don't have is, as we've indicated, the transcript of the evidence from Dr. F. That's what, as I've been instructed, 48 minutes. The mother and the father and the guardian. And the simple point that I make in relation to that is that we don't know what Mr Justice Hayden left out of account in the summary or the record that he provides of that evidence. And I'm not able to help you because obviously I wasn't there before the court, but necessarily a judge's task is not to scribe down everything that's possibly said. So those transcripts are not there. I am instructed that Dr. F's oral evidence included cross-examination about the option set out in the 10th of July letter. And that is something that doesn't feature, that the record of that doesn't feature within the judgment.
Well, Mr Devereux helped me with this then, because we have, of course, got Ms Watson here as well, who heard that evidence. Now, I've, in common, I'm sure, with the others, read Dr F's response to the letter, which we find
Dr. F gives a second statement, doesn't she?
Yeah. It's page 302, tab 20.
Yes.
Now, that, without going into the huge detail, it's perfectly clear from that statement that, particularly if we look at paragraph 12
Yes.
and 13, that the proposal, in her view, as
Yes.
expressed in that witness statement, is that the proposal would lead to the potential to lead to a chaotic and very difficult death.
Yes.
Now, is it said that Dr. F said something different in cross-examination? So,
Could I just turn my back?
of course,
Thank you. Right. There was, I'm instructed, a discussion and cross-examination about the use of the word chaotic and whether in fact any decline and end would be chaotic.
but it said potential to be chaotic.
And this particularly focused, I am instructed, on the fact that there was a question over the DNR notice, and once it was accepted that there wouldn't be attempts to resuscitate, the chaotic nature of any decline and end fell away. There seems to be some dispute about that.
These submissions are to your overall point, which this court doesn't have the material to retake the decision itself.
And even this exchange rather identifies.
What was not said by Dr. F about something which is not going to happen doesn't seem to me to impede us from taking a view, if we have to, as to the best interests.
Can I turn my back? Our response to that is that the option within the letter still remains a live option, and therefore what Dr. F said about it is relevant.
So paragraph 12 of the statement, so the cross-examination went to the word chaotic. Paragraph 12...
Well, I think it probably went beyond the word chaotic, but there was, your focus was on chaotic, and I...
No, my focus was that the proposal in the letter, made for understandable and no doubt the best possible reasons by the family, was the withdrawal of the vasopressin,
yes.
and the evidence was that the result of that would be, without going into huge detail, that he'd become rapidly and severely dehydrated, his blood pressure would fall and his heart would stop.
But it would generate a crisis.
And it would generate a crisis.
But that's not what it says, but that in summary.
And what Dr. F was saying is that had the potential to be chaotic and unpredictable.
Yes.
As opposed to a planned withdrawal of the ventilator.
Yes.
But so just so that I'm clear, the family's proposal now and choice would be for the withdrawal of the treatment in a different way.
That they have two.
By the withdrawal of this drug.
Either that or their other position, which is that there shouldn't be withdrawal of that drug. But what I'm being buffeted from both sides.
Are you sure that's right?
I don't.
Right.
I really do need to be clear about this.
Well, so do I, my
because
lady.
I want the parents to, for us to understand. Are they really
It is surprising to me that the parents would have that.
What the position is, I've had it clarified, is not a withdrawal but a limitation of vasopressin as a part of the option of the 10th of July letter. And their other option was to continue until such point as the end came in whichever way it came. Those are three options that seem to be open to a decision maker.
Could you just clarify what your position is in relation to what Miss Watson told us, which was that when the matter came before the judge ultimately, he was faced with only two options, not this intermediate position?
My instructions were the three options were pursued, but the judge made it very clear that he was not minded to go with the limitation of vasopressin 10th of July letter option. But the cross-examination of Dr. F did take part on that basis.
Yes, but in the end, it doesn't seem a very likely possibility that by the time the evidence and argument came to the end, the parents' case was being put on the basis of two alternative grounds of
no, I think the position
of difference, but the judge then doesn't refer to,
no, I
to one of them at all.
I think, and these are my words, that the judge had expressed himself in trenchant
Yes, but
terms
in a
about...
sense, it doesn't really matter how we get to the,
No,
the
I
end
understand
point,
that.
because I'm at the moment not clear what the basis within an appeal structure is for you to launch an appeal. If we're talking now about the appeal having hypothetically succeeded,
Yes.
with this court then having to consider whether it should make its own decision or to remit for a further decision to be taken.
Well, as a matter of principle...
I'm
sorry if I interrupted.
But at that stage, you're asking us to take into account the resurrection of a third position, which you say we're not in a position to deal with.
Well,
That's how it comes in.
yes.
I'm just wondering whether that's, as it were, whether that runs.
Well, as a matter of principle, my submission on this would be as follows. On the hypothetical that I succeed in relation to my appeal, there are two options. There are two possible outcomes. This court makes the decision, it exercises the evaluation itself, or it's remitted.
Yes.
Now, on either of those outcomes, it must be open to me to put forward whatever arguments that I can and am instructed to do reasonably in relation to a best interest outcome. And if I wish to resurrect, or the parents wish to resurrect, a point that the judge made it clear that he was not minded to agree with or go down with or follow through, then that doesn't prevent me, I submit, from saying to this court, as standing in the shoes of the decision maker, from saying, right, it's back to where we are, all options are open, and I want to...
Yes, but
make
in
those
considering
points.
whether the matter would then be decided here or elsewhere, one would then need to look at the viability of whatever the argument was.
Yes, and one of the further points that I was moving to make was on this heading was in the time permitted to the parents' legal team, and I make no criticism of anybody, but there's been limited time, just as a matter of fact. We have focused all our energies, for better or for worse, on trying to establish that Mr Justice Hayden fell into error. Our focus has not been principally, or indeed specifically, on an evaluation of best interest by this court. Now, the court may say, well, you should have thought otherwise, but I'm just indicating that that is the reality of the situation that we're in, and it's a point that I make in favour of remission, and potentially my learned friends might, with a heavy heart, agree their positions were similar. Certainly the level of detail and focus on best interest submissions before this court has been abbreviated. And the court can pick up, at least from my position, that I'm having to take instructions as we go along on difficult matters that have the most profound consequences. And that...
I understand that, but I have difficulty with the idea that the judge might have had some jurisdiction to adjudicate or make a direction or a declaration about the middle course. The application of the hospital trust is to a declaration that it will be lawful to withdraw treatment when it's best interest for the treatment not to continue. So that's, as it were, a single option. That either succeeds or fails. For the judge to say that option is that application is dismissed, but I direct that the trust are to reduce the level of vasopressin that's administered, and the doctors presumably think that the current level is the right one. I don't know that the judge has jurisdiction to
Well, I accept
to tinker with
It's rather like
a very
plans, care
sophisticated
plans.
care plan, yes.
But we all know, and this court knows better than I will ever know, that on a practical level there is a cooperative nature
It's
between.
not for the judge to. The parent's letter says that the parties agree to an appropriate ceiling of treatment for. The parties shall agree to an appropriate ceiling of treatment for Archie, so that the trust shall be under no obligation to escalate treatment beyond a certain level if his condition deteriorates. Then this may include a ceiling on the amount of vasopressin Archie will receive in the event of deterioration. Well, that's a very subtle matter, and I can't see, even as a matter of law, that a judge would have a say in that, but it certainly shouldn't have a say. You can't have judges who are day to day adjudicating upon the drug regime of an extremely vulnerable individual.
What one can have, and what one does have in my submission, is a cooperation between trust, parent and court to come to a consensus view. One has this, for example, so often with DNR notices.
In the end, that's right, and one hopes that's right in every case. But if there is a dispute between the parents, if the parents are insisting, as I think you're submitting is the case, that the view of the hospital as to the level of vasopressin should be overridden by Mr Justice Hayden having made a decision, or this court making a decision about that, I don't understand what jurisdiction the court would have.
I mean, I venture to suggest, just on my feet, that the judge would be able to make a declaration as to the lawfulness of, for example, a particular step taken by the hospital. And it just so happens that this is a specific treatment-specific step, but that happens.
Your submission would be that we, when we're taking the decision, should declare that it's unlawful for the trust to give vasopressin above a certain level of dose?
Our position would be that there should be an adoption of either of the two options that the parents put forward. So therefore, my lords and my lady, what we ultimately submit is that this court would be making a decision in relation to the most profound matter on the basis of incomplete evidence.
Well, I've written down the list that you have given to us in the course of this submission. The court hasn't got all of the written evidence. You've agreed that the court doesn't need to go to the medical evidence at all. You then submitted that the court didn't have Miss Carter's statements.
Yes, and I was shown to be
established
wrong
that the court
about
does. So far, nothing identified that the court hasn't got that it needs. You then said that there isn't a transcript of Dr. F's evidence, and that's the point we've been on.
Yes.
So it's a matter for us to decide whether we would need that. And so the identified material the court hasn't got is, leaving Dr. F on one side, is the absence of a transcript of the mother and the father and the guardian's oral evidence.
Yes.
And on the basis of that, and this is a proper submission you can make, you say, therefore, we're not in a position to retake the
in addition,
decision.
You haven't received focused and specifically prepared submissions on these profoundly important matters. I'm doing my best.
I understand that, but what, in a sense, the submissions that were made to Mr Justice Hayden, we have, and that was...
Well, I'm not sure you do have, because you don't have the oral submissions that were made to him, and they're not recorded within the judgment. What you do have is the position statements.
I mean, those submissions were made, I think, this day week.
Yes, but they're not recorded in detail in the judgment, and you don't have a transcript of them.
So that's the point.
and perhaps I'm repeating myself, and the court will forgive me for so doing, but in a matter of this consequence, it's obviously important that the court has everything, every piece of information, every piece of assistance at its fingertips to be sure in the knowledge that ultimately the court makes the right decision for Archie. And I simply submit on behalf of the parents, with the legal team behind me, that it doesn't.
Thank you. Well, we're very grateful to you all, and if I didn't say so yesterday, I for myself am particularly impressed by and grateful for the team of people, I don't know which party they come from, who pulled the bundle together and all the authorities together, because they are unsung heroines and heroes, because this has come on at such short notice. We will rise now. As I indicated this morning, we'll endeavour to give an oral judgment on all of these matters at 11:30 on Monday morning. Thank you all very much.
Bye.